Hello, Dr. Yerby here. I wanted to quickly talk about a Fourth and Fifth Amendment and how this relates to mobile forensics or mobile devices and your rights and things as a citizen of the United States. So our Fourth Amendment, again, that one's the one that pertains to searching and seizures, and it means that a person needs to have a warrant, right, or a law enforcement officer needs to have a warrant to be able to search your device, your home, something like that. So it needs to go to some judge, and they need to make a case of why this thing needs to be searched. The Fifth Amendment is a pretty large amendment that we don't talk about too much, except for when somebody says they take the fifth, right? So let's talk about what taking the fifth is, then we'll talk about the amendment. So a great website where you can get all sorts of great definitions is urbandictionary.com. But basically, taking the fifth, it's refusing to answer on the grounds that one may incriminate oneself. Okay, so let's watch a short video of someone taking the fifth.
I plead the fifth. I said there are so many amendments in the Constitution of the United States of America. I can only choose one. I can only choose one. I plead the fifth. I plead the fifth. 5, 1, 2, 3, 4, 5. Anything you say, fifth. Go ahead, ask me a question.
Did you?
Fifth. I have a secret document that I think you need to say.
Okay, I hope you enjoyed that. Now let's actually look at what is involved in the Fifth Amendment. So over in the white part here, you can see what the Fifth Amendment is. It's pretty large, so I'm not going to read it all to you, but you can pause the video and read it. The thing that we're most concerned with about when we're talking about our mobile devices is this protects against self-incrimination. Right, so we have the device, and perhaps there's some act that's been committed where our device has information on it. Either it has some GPS coordinates, or we've connected to a network somewhere, or we've taken pictures or text messages, or whatever the suspect has done. There's information on the device. And before there was case law, where a case had gone to a court and the court had ruled on it, it was kind of pretty common for a suspect to be detained by a law enforcement officer and for them to search the phone looking for anything that could be related to officer safety. Right? So we certainly support our law enforcement officers out there, but the issue that our privacy rights groups were finding is that the cops were really not doing this for officer safety as much as they were looking for other related crimes. So the Supreme Court ruled, I believe in 2013, that the police generally may not search cell phones of Americans who have been arrested without a search warrant. So if you've been arrested, detained on the side of the road, or arrested, but there's no search warrant for an officer to search your device, just like this beautiful doormat says here, they need to come back with a warrant. So the big differentiating factor in there is this protects against self-incrimination. So that means that the person does not have to do something that would be considered testifying against themselves. Before cell phones, a search of a person was limited by physical realities and generally constituted only a narrow intrusion on privacy. But cell phones can store millions of pages of text, thousands of pictures, and hundreds of videos. This has several interrelated privacy consequences. So there were two cases that went before the Supreme Court when they made this ruling. One was Riley versus California, where a person was compelled to open their phone, and the other one was United States versus Worry. And so the basics of it is they were challenging the legality of warrantless cell phone searches under that Fourth Amendment that we're talking about. So the courts ruled that these searches were not lawful, and so now that's the law, that if a person is detained or a device is seized, that in most cases there needs to be a warrant. Now, one of the caveats in the statement, so there's a professor who is kind of the go-to authority in this. It's Dr. Orrin Kerr. He's a law professor at George Washington University. And so the difference here is when I try to open this device and I try to get into the device, I see I'm presented with some sort of lock code. So this is something I need to know. I need to know either a PIN number or a pattern or some sort of lock. So if a law enforcement officer wanted to search this device, they need to know that PIN code. And the Fifth Amendment says that you can't compel me, you can't force me to give that information over as a suspect, because I would be testifying against myself. So the difference here is, well, what if it's a PIN code? So it's locked, and I'm going to press my finger on here, and when I press my finger, voila, I'm in. So is a PIN or a pattern the same as a fingerprint? So thankfully, there's case law. There's cases that happened much more recently. So in January of 2017, there was an appeal, the Minnesota court, on the Fifth Amendment and compelling fingerprints to unlock a phone. So the case was State versus Diamond, and by being ordered, the first part, the court concludes that forcing a person to place a particular finger on a phone does not trigger the Fifth Amendment because it's not testimonial. So you see that they talk about a particular finger. So where's your particular finger? Is it that one? I always call this the index, the pinky, the thumb, or the one you put up when you don't. So what does that mean? The particular finger, that was this person's grounds for appeal. They said that first, he didn't want to unlock the phone, and so they said that they're going to hold him in contempt of court. And they said, if you do give them your fingerprint to unlock the phone, the civil contempt will go away. And so he provided his fingerprints, unlocked the phone, police searched the phone, and he appealed it, saying that, hey, this was a violation of my Fifth Amendment right, because I didn't just provide a fingerprint. My fingerprint's not testifying against me, but when I tell them it's this finger, I read between the lines, right? When I tell them it's a certain finger, that's some knowledge in my head that I've had to give to the law enforcement to testify against myself. So the person's argument was that this was a violation of his Fifth Amendment right. So in the rulings, it says it's clear that the district court permitted the state to take samples of all of Diamond's fingerprints and thumbprints. The district court did not ask which prints would unlock the cell phone, or even if a print would unlock it, nor did the district compel Diamond to disclose that information. There's no indication that Diamond would have been asked to do more had none of the fingerprints unlocked the cell phone. Diamond himself asked which fingerprints the detectives wanted, and when he was ready to comply with the order, the detectives answered his question. Diamond did not object to them, nor did he bring an additional motion to suppress the evidence based on the exchange that he first initiated. So the explanations for this, that he was not required by the order to tell which fingerprint would open the phone, and then suggest that Diamond didn't object to carrying out the order. So I'm not sure, but this is how case law is made, is that something happens, that goes to case, courts make a ruling, and until a higher court makes a different ruling, that's case law. So That's how the Fourth and Fifth Amendment currently relate to your mobile devices. So again, in summary, if it's protected with a passcode or PIN or password, that's something that you can't be compelled to turn over. If it's protected with biometrics, that's something that it seems is compellable, is obtainable from our law enforcement friends, and they are able to get into that device. So think about that when you're going about your day, living your life, working in whatever field you may be. You may be a law enforcement officer, you may be a defense attorney, or you may be Saul Goodman, or whoever that needs to give advice to people who these types of laws may apply to. So that's just some information for you. Thanks. This is Dr. Yerby.